So mediation is going to be a required process for any contested divorce. The way mediation works, it's a confidential process where you, your attorney, your spouse's attorney will come and they will meet at a mediator's office, or sometimes these days we're doing them via Zoom. The mediator will be a neutral party, not loyal to either side, who's usually an experienced attorney, normally a former judge. They're going to go back and forth and try to make an agreement between the two parties. Normally in any negotiation, there's going to be a difference at the beginning where one side's over here, one side's here. The mediator is going to try to move the parties closer and closer together until they can reach an agreement. If you're able to reach an agreement in mediation, it is going to be a binding agreement. It is an irrevocable settlement that cannot be undone. There's advantages and disadvantages to this. The advantage to this is once you have a binding settlement agreement, you know your case is over. You know nobody can go back on that. So the other side's going to be locked in. The disadvantage to that is, for the same reason, you can't change it if you want to change it. So it's very important when you go to mediation that you know exactly what you're willing to settle for and that you're not going to be dealing with buyer's remorse the next day. It's very important you read every word of what you're signing and that your attorney explains it to you very thoroughly so you know exactly what you're agreeing to before you agree to it. One of the biggest advantages to mediation over litigation is that it's going to save you time and money. Contested divorces on the low end could average around $10,000 start to finish, sometimes a little bit less, or they could go $50,000, sometimes even higher. Litigation is very expensive. With mediation, you can get ahead of all of that. You can put the work into mediation if your partner is willing to put the work into mediation to try to reach an outcome that is definite, certain, final. And if you're able to do that, it's assuredly going to be much cheaper than going to court. There's so much more work that has to go into court. Mediation is a 4 to 8 hour process. You could have another 4 hours of prep for the mediation. Trial is sometimes up to 100 hours of prep for trial. So by resolving your case in mediation, you will undoubtedly save yourself both time and money. Now, one thing that's important to understand and appreciate, in mediation, you're never going to get everything that you want. If you were going to get everything that you wanted in you wouldn't even need to go to mediation because the other side would have already been agreeing to give it to you. So you're going to have to be willing to give a little bit as well. Normally, mediators will say when both sides leave unhappy, that's a good mediation. Both sides gave more than they wanted to. If they were able to find a middle ground, that's appropriate. Normally, the courts are going to require you to go to mediation, usually twice. It's going to be required for temporary orders. It's going to be required for your final divorce. You just have to go into mediation knowing what you're willing to settle for and knowing what you're not willing to settle for. If you're not willing to settle for things you just consider this a non-negotiable, that's a perfectly reasonable strategy. Just know what you're willing to negotiate for and know what you're not willing to negotiate for. If you have questions about mediation or any other aspects of the divorce process, please don't hesitate to give us a call at the Bayley Law Firm for a consultation today.